Hello, welcome to Let's Debate. My name is Oluyemi Orija and I'm a legal practitioner, but today I'm not here as a lawyer, but I'm here as the moderator of this show. And if you don't know, this show is put together by Hedford Foundation, an NGO focused on decongestion of Nigerian prison and empowerment of ex-inmates. Hedford Foundation has in the past helped 121 people out of prison, and we want to reach out to do more. However, in the course of our work, we have realized that lots of Nigeria really do not know their rights and the law. So we have put up shows to enlighten the public on their fundamental human rights and what is actually happening in the justice system in Nigeria. So this show is one of it. Thank you and welcome. Today we are going to be talking about the delay we have in determination of criminal justice. Who are those people responsible for the delay? Is it the court and the prosecutor, the lawyer, or the accused person? So today with me, we have two legal luminaries that will be doing justice to this topic. To my right is Mr. Olumide Ajibi. Welcome and thank you for joining us.
Thank you very much.
And to my right, to my left rather, is Mr. Todimo Ige. Thank you, sir, for joining us.
Thank you for having me.
Yes, yeah, thank you. So Mr. Olumide is been in practice for almost a decade, and he's the managing partner of Dew Point Legal Practice. So also Mr. Todimo Ige is been in practice for almost a decade as well, and is the managing partner of Todimo Ige and Associates. So before we dive right into the topic, I would want to lay the foundation of what we are actually talking about. So the thing is, for our viewers, I know you have heard or you've seen one person that has been arrested at one point for whatever crime in Nigeria. And they've been arrested, probably charged court, and landed in prison. Fortunately for some, they are able to perfect their bail and they're out of prison, while others remain there until determination of the matter. However, while the matter continues to linger in court, we've seen criminal matters been in court for 5 years, for 4 years, for 6 years, and our worry is, why do we have to wait that long to get justice? Why does it have to take that long for a court to determine who is guilty or innocent on a particular crime? So those are the things we are going to be talking about today. So I will have Mr. Olumide have the floor for about 5 minutes. Tell us, Mr. Olumide, what do you think? How do you think that the lawyer and the accused persons are the ones responsible for this delay?
Well, thank you very much. First off, the judicial system has been set up to actually get justice done, and just not to be done, to have been seen, to have been manifestly done. And that is why the courts are there to do their job. That's why the prosecutor has been put there to ensure that justice is served at every point in time. But what we have come to see, according to the late Shibolage, he said in the year 2000 that many lawyers have not even, many young lawyers have not been able to see full trial, because it now seems as if the tactics for this day is to see how a case can be delayed to a long period of time, so that justice can even be evaded altogether. Having said that, what are these things that usually see defense counsel and their clients do most of the time? That is the accused person. They bring forth all kinds of delay tactics. For example, once somebody is being arraigned, you see that an application is brought challenging jurisdiction of the court. That can linger for months before the court will finally get to deliver a ruling on that. Upon delivering a ruling, the next you see they bring another application for stay of proceedings, pending appeal. They will stay the proceedings of the court, go all the way to the Court of Appeal, and even to the Supreme Court. That can take a number of years. Peradventure, if the Supreme Court says yes, the court has jurisdiction, they come back to that same court. The trial may begin. You see them, they file an application and say, oh, our client does not have confidence in this court again. We want the judge to recuse himself. That may drag on for another couple of years or months, dragging that as well. As if that is not enough, you see probably at the point of tendering the statement of the accused, objections here and there, that oh, the statement was not made voluntarily. The matter goes into trial within trial. That alone can take years to come out from. These are things that ordinarily shouldn't arise most of the time, but because the lawyers know that, well, my client is out in the street, he's doing his business, nothing is disturbing him, so we can keep the case in court for as long as it can take. In as much as we keep it there, my client is free and can do whatever he wants at that point in time. What do we want to talk about? Issue of people writing letters of adjournment at every point in time. What about the absenteeism? You see, you are in court today, the client, which is a key person, may be there. We have witnessed this many times. Where's your lawyer? Say, my lawyer said he's stuck in traffic and the matter is for trial. I say, my lawyer called me this morning, he said he's sick, that I cannot come to court. When they know that a crucial witness will be taken that very day. What has happened? That proceedings have been frustrated at that point in time. Especially when you see cases in which you have many defendants. One of them may call today, the other, on the next date, another one will have sent himself, knowing that all the defendants have to be present before trial can actually go on. So these are things that I've witnessed personally, and it is so frustrating. I have many matters pending now for years. Why? Because it's either you see one of the clients of the accused person today, tomorrow is here, he has done bail, we are looking for him. So many cases have been hung up like that. Why? Because they are still looking for the accused person up to today, and the court will keep it in the docket. They won't strike it out because the accused person is at large. They are looking for him. How do you blame the prosecution for that? It is not their fault that the accused person jumped bail granted him by the court. These are issues. Now, in year 2006, I think that should be GWOK or something like that, during a summit on the administration of justice, he said emphatically that even some people go as far as filing some frivolous appeals just because they want to become SAN. Because they want to become SAN, they know that, oh, if I don't appeal this thing, I won't have the opportunity of going to the Court of Appeal and to the Supreme Court. So because of that, they file all kind of applications. Once the court rules on it, they file notice of appeal, ask for stay of proceedings, jump to the Court of Appeal. From there, if the ruling does not go in their favor, they jump to the Supreme Court. Why? Because they want to chase clout, as it is called, or because they want to be called a learned sick. So these are things that defense counsel do at every point in time that we have seen in so many cases. One of such cases is Abacha and State, in which they filed application on issue of jurisdiction. They went all the way to the Supreme Court. The case lasted for almost 5-6 years in court without any tangible conclusion. Why? Because the defendant just wanted to frustrate the process. And these are things we see in many of these political cases, that we see them linger in court for 7-8 years. And people be like, this man has been arraigned in court. That's why people are even losing interest in the judicial system, because they're like, oh, this matter has been in court, it's been there for 8 years, this man who embezzled their money will not send justice served. Who do you blame? Go and ask the defense counsel. They've done everything to frustrate the court. It's either they are asking that, oh, beloved, we want to change the forum. Knowing that once the forum is changed, the matter has to start de novo. Everything that has been done in the trial process goes down the drain. All the years that have been wasted, all the resources, everything goes down the drain. These are things we see on a daily basis in many of our courtrooms. So these and many more are things that are being done that actually frustrate the way of justice and prevents it from moving. But at the end of the day, everybody comes out and says, oh, the court the court. It is not the court. Go and ask the defense counsel what they do. How many times have we heard the court asking an accused person that, oh, if you don't come with your lawyer on the next date, I will have to go on with this case and you have to defend yourself. Why? Because the court is frustrated that this matter has been lingering in my court. I am not moving forward, and yet the lawyer is not here, or the decision he said, oh my lord, I'm sick today. Oh my lord, I'm before the higher court. One thing or the other always keeps the lawyer away from the court, and it leads them to threat and say, look, I will do something about this. You will defend yourself in person, and will conclude this case whether you like it or not. I've seen a case where the judge said, look, Mr. Man, whether you like it or not, we must finish this case in this court because this case has gone through 4 judges already. Why? The defendant keeps doing one thing or the other to frustrate the case. So the judges get tired. It's either they recuse themselves or probably elevated to the higher bench, or the judge gets transferred to another. They will say, no, we cannot go to the new jurisdiction. It is far. We want to stay within this jurisdiction because this is where the crime was committed. So we like this forum. So the new judge comes in, they start the frustration process again. That one ends up, whatever happens, they start because they just want to frustrate justice. So it is not the prosecutor. They are always there in the courtroom, day in, day out, ready to do their job. But what do we have on the other side? Counsel is behaving. Some are lazy, they are never ready for trial. Some will come and say, my lord, I've just been retained. They're on the day for trial. My lord, I've just been retained. I need to study the case. My lord, I need to get record of proceedings or the past witnesses so that I can review it in order to cross-examine the witness. These are things we've seen over and over, and it is frustrating, it is annoying, and something needs to be done about it. Thank you very much.
Wow. I mean, yes, I'm a lawyer, but really I've learned a lot from what he said. But however, we cannot hear from one side and not hear from the other. Mr. Todimu, you think that the court and the prosecutors are the ones responsible for this delay. Can you tell us how?
Thank you very much, Mr. Olumide. I've spoken so eloquently, and in fact, I would say, well, have I taken the wrong side? But the truth of the matter is that the duty of the defense lawyer is to identify the loophole, because that's why you are defending. Once you are able to identify the loophole, you can pick on it and enlarge it. So having said that, you will see that the defense counsel, their duty, like I said, they are paid to identify the loophole. And you would, of course, agree with me that the loopholes that you have mentioned, that the defense counsel have been able to chip in and expand and delay trial, is as a result of the laxes on the part of the prosecution and the court. Because if there is no loophole, okay, I don't know, Yoruba people say that if the wall is not open, the lizard does not crawl in. Now, having said that, you will discover that the prosecution and the court, why do I hold them responsible for this delay in trial? Most times, trial, don't forget that before we go to court, that's prosecution, before an accused person is brought to court, the police ordinarily ought to have done their investigation, sent their reports to the DPP for whatever approval and say, oh yes, this person actually has a case to stand. But you discover that for the first 6 months that the matter is brought to court, we are waiting pending DPP approval, pending DPP advice, we have sent the file to someone else. That takes about 6 months. At times it could even be more than a year. That's for someone who has a diligent counsel. Because I've been in court before, and over time, that the judge will even say to the defense counsel, don't wait for them. If possible, mobilize yourself and go to, it's not the duty of the defense counsel to be looking for files up and down. Because I don't see that happening if it were to be a civil matter, where both parties are independent, both lawyers are independent and remunerated by their clients. I don't expect that the other lawyer will wait for me to go and do my own investigation before getting the result. So having said that, you will see that the prosecution they do a shoddy job of, first, in the process of arraignment, get all your facts right. The police and the law enforcement agencies are always eager to make an arrest, to charge to court, to be seen to be doing their job. Mr. Olumide rightly said, the prosecution, they're always in court. Yes, it's not about being in court, but are you there to do? You see, most times, and they say, oh, it's now the case of Todi versus state, or the state versus Todi. That's when they start looking at the say, witness in court, IPO, you are the IPO. You know, at times, it's so annoying. Ordinarily, the defense counsel would have come to court, even a day before, 2 days before, 3 days before, grooming their witness. This is what you should say, this is not what you should say. And the IPO is coming, or the prosecutor is coming to court, seeing the witness for the first time, does not even have the background of what is happening. So you will see that at times, again, I must mention, having said that, they rush to charge without conducting their due diligence. Having said that's one, and you see that there is no way, because how would that lead to fair hearing when you have not even done? At times, you just wonder that you see some minor, they make so many elementary mistakes. At times, they even charge, or they bring a charge that is not found in law. So why is the state paying so much for someone to come and do a shoddy job? Most times, I can assure you that most cases, when it comes from the magistrate to the High Court, to Federal High Court, you will see that the defense counsels, they have easy victory, they have it cheaply, because the other side is never prepared. You will see that most times, you defeat them on, like Mr. Olumide said, I've been in court once, and the prosecutor was, the defendant said that my lawyer is sick, or something. The procedure of the law is that if you are saying that you are sick, there must be a notice to the court in form of a letter. Because I was holding watching brief, I had to call the attention of the prosecutor. No, we won't take this, because there is nothing before the court to show that this person is sick. The prosecutor, because he doesn't know his job, or probably they feel less concerned. So those are the delays that the defense counsel exploits and sees. Oh yes, we can actually exploit this. Number two, like I said, number two, which is an offshoot of a poor diligence check. Number two, the court is to administer justice between both parties. Now, when the prosecutor comes to court and is not prepared, ordinarily, you see that, thankfully in Lagos, because we are looking at Nigeria as a whole, you will see that in Lagos, most of the courts now give multiple trial dates to ensure that these matters go on as speedily as possible. Now, you will now discover that most times, it takes forever for the prosecution to make their case. When it comes to the defense, you see, you know the facts are there. When it comes for the defense to open their case and defend and close their case, most times, you will even see that most of them say, oh, we rest our case on the prosecution. Why? Because they know that they have done nothing. Because you will see that they have done nothing. Most times, you just wonder what is happening to these people. Elementary issues that ordinarily should be trashed. As a matter of fact, if the prosecution is coming to court, you already know that this is an offense that is bailable. They just come. This is your case. You don't let them grant the defendant bail. They just come. At the end of the day, you waste 2 days over bail application. Ordinarily, they say, oh, go and verify the shorties and all that. It takes forever to do all that. You will see that this is not the fault of the defense counsel. You can't blame me for that. I would, of course, because every profession has its own bad edge. Ordinarily, we should all be ministers in the temple of justice to see how we can ensure that justice is done, and it should be not just done, but seen to be done. That you will see that the prosecution, most times, they just most times you would even see that when they come to court, you already know that your witness is not going to be in court. Why don't you write to the court and say, oh, please, we ask for another date, give us a further date. You come to court and not pretend as if you were caught unawares. Oh, IPO, James has been posted to Sokoto. IPO, did you leave a file? What's the essence of the bulky file that they come to court with? If justice, do you understand? Yeah. So that's number two. Number three, you will discover that the court is responsible for its file docket. The case file, the court list is generated by the court, not by any other person. If the court knows that I cannot do 15, 20 cases in a day, streamline it and ensure that you would attend to all the matters on your job. You attend to all the matters before you in that day. It's not about being busy. At times you see a lot of people being busy and not achieving any result. But left to me, I prefer where you have a cost list of 10 people on the court list, but you know that for those 10, for a week, you are done with all the matters. But you just see most, I don't know, for whatever reasons they do that, you see that when, especially those that handle criminal matters, you see about 35 cases, 37 cases.
For a day?
Yes. So, even if you are a machine, there is no way that you will be able to handle those matters effectively. So, and that, you can't blame that on the defense counsel. You can't blame that on the defense counsel. Number 4 is that you will discover that the courts, you will see that the court belongs to the judge, it belongs to them. So if the court says, you know, there are some judges that you don't come before them and you don't try some frivolous activities, and you say, oh, I know that, and you just come into the, I find it funny, I find it before some certain justice and say, oh, I'm sorry, I just got the thing, I just got the brief. Because I've seen at this and you have been here sitting for over 2 hours, pressing your phone. In fact, I'm sure that counsel, you will feel pity for that counsel. How many years have you had the buyer? 5 years. You must do this today. So when it's mandatory, nobody will come to play games. We have seen instances like Mr. Olumide said, a lawyer intentionally came improperly dressed because he knows that he will be sent out. But what did he just say? Okay, you know what? Go outside and change your tie. We'll step down this matter. Do you understand? So if such checks and balances are there, it's there, but it has to be enforced. It has to be enforced. So I think that, I haven't said that because I know that we'll still dig into the issues more, but you will see that basically the defense counsels are exploiting the loophole and the ineffectiveness of the prosecution and the court itself. And I think that the court should step up their game. The court should step up their game because I'm sure that Effort Foundation, most of the cases that you have won, because I see your updates, most of the people that you get out of the prison. Why? Is it because of the defense counsel? It's because of the wishy-washy behavior of the prosecution. How can somebody be in prison for 2 years awaiting trial? He has not been brought before any court. That is not the duty of the defense counsel. It is the court. There are provisions that magistrates should ordinarily, with every 21 days, go to neighboring prisons and set people free if they have not been brought to trial. How many of them do that? We can't blame the defense counsel for that. No. I think that I'll rest it here.
Wow. It's been awesome. It's been educating and entertaining. I have learned, but we are not done yet. So, Mr. Olumide, I mean, when you were talking, you referred to lawyers that hang cases at the High Court, probably, and go on appeal, or that's what we call interlocutory appeals, then come back on the ground that the court does not have jurisdiction. I mean, I learned that at some point there was a law, that's the Criminal Justice Act, that was passed into law, and that law specifically said that there should not be room for interlocutory appeal. I also understand that laws like this has to be domesticated by all states in Nigeria. I don't know whether all states in Nigeria have done that, and I really want you to shed light on this, whether all states have done this, and whether people are still going on interlocutory appeal up to the Supreme Court level, then coming back to the High Court. Please kindly shed light on that.
On issue of interlocutory appeals, specifically like the EFCC has, Section 40 specifically says that if there is any interlocutory appeal, that the matter should not be stayed, that the judge will continue until final judgment, and then if you want to appeal altogether. This is just done in order to curtail some dragging of cases by the defense counsel, actually. So that has been put in place, and the Administration of Criminal Justice Act also makes such an application, such a provision that interlocutory appeals can be taken all together at the end of the trial, so that cases can move. Because, like he said, these are things that defense counsel exploits in our law. Yes. In our law. Yes. So this has been done at the federal level. But being a federal system of government that we operate in Nigeria, it has to be domesticated in each of the states. I know not many states in Nigeria have done that. I know Lagos State, of course, always moving with the tide. Yes. They've done that. Yes. I know Ogun State did that recently, I think that should be last year, but not all the states have done that. So in states where that has not been domesticated, then a case can hang there for as long as possible. They are challenging jurisdiction. Because they will say jurisdiction is the foundation of the case. If you don't have jurisdiction, then why are you sitting on it? Yeah. So these are not being domesticated, and these are things that each state needs to take pragmatic steps to ensure that it is done, so that nobody will be able to exploit this thing to frustrate justice at any point in time.
Okay, sorry, I would like to also ask that at the end of the day, like all the stakeholders we have talked about today are in existence so that justice can be achieved, right? So I am wondering that why would a lawyer, if I am representing a client, for instance, and I really know that this client is probably not guilty, or I even feel that he's guilty, we want justice for the victim, we want justice for the defendant, and we want justice for the society at large. So if we all have this at heart, why would lawyers want to, look for loopholes somewhere to elongate the duration of criminal trial? Why do you think lawyers do this?
Well, it is said that we as lawyers are ministers in the temple of justice, and our first obligation is to the court. Yes. Not even to your clients, your first obligation is to the court. But as it is, the society has, one way or the other, changed the orientation of some people. So, and it has changed their focus from being ministers in the temple of justice to being servants of their clients. And so, they do the bidding of the clients. And so, well, it is said that money answers all things. So when money has been given and is continued to be given, in as much as the case is in court, yes, the lawyer keeps getting paid, yes, he keeps getting money. Then, if I keep getting money from a fountain, I wouldn't want the fountain to dry. So I will keep holding the fountain there for as long as it takes, in as much as I keep getting paid from that point. So these are some of the reasons why they do that. And also, some also have, maybe they don't have many cases to do. They want to look busy, so that don't be as if he's always sitting in his office not doing anything. So that single case or the 3 cases he has, it will take forever to drag it in court. That no, I must drag this case. Like Ariori and Elemo. I must drag it. I must drag it. I must drag it. So that at least I'll keep going to court. Yes. I keep collecting appearance fee. Then I can write to the client and say, look, this case has taken 5 years. Can we review our fees? These are things people can do. Yes. Because even if you are not doing about, because you know the brief is fat, so they go to any length to defend the client. And so they don't mind doing anything to make sure that the case does not reach an end, especially when they have a bad case.
Yeah. Especially
when they have a bad case. And that was what Shibola Ige alluded to when he made that speech in the year 2000. Especially when they have a bad case, that they will keep dragging the case. That it has become like that's the new thing you need to learn. To drag it, cases so that it will not come to an end.
Okay, I would also want to, or maybe this is the last question I'm going to put across to you. But at the end of the day, I think lawyers that do this are doing it when their clients are out on bail. For the ones that are in prison, for some they do not have legal representation, and that's why Help Foundation have tried to fill that gap and represent them for free. So for others, they have legal representation, and even at that, the lawyer, and they're still in custody, the lawyers still don't show up. Well, I mean, so if you say that it's whether they have, when they have bad case, however, whether or not they have bad case, and your client is still in prison suffering, why do you think lawyers still will not show up in court for whatever reasons and keep the client in prison?
Well, first, like I said, your duty is to the court, and you hold the court a duty to ensure that you give effective representation to your client. Even the rules of professional conduct states that you must do the best, to the best of your ability, defend your client. So such lawyers know it within themselves that we are going against the rules of professional conduct. And many of them that I call in a colloquial language, I say they are resident lawyers, because you only see them in the court. Once they collect money for bail, probably the person wants to pay but does not have money to pay, they disappear. But some that are even paid will not still appear, and they keep doing all sorts of things. It's just because they don't want the way of progress or the will of justice to move forward. And such lawyers need to be dealt with according to the rules of the profession, especially in criminal matters when the liberty of somebody is at stake. And that is why they even say you should not even reject a criminal brief. To see the importance attached is paying, and that even when you are doing that, you should give your best representation, notwithstanding that the client is not paid, that you are doing a pro bono. You should give the best. It is because the liberty of somebody is at stake, and so you need to do something about it. So such people should be dealt with according to the rules of the legal profession.
Wow, thank you very much, Mr. Olumide. So, Mr. Sotimo has constantly said the courts and the prosecutors are responsible for the delay we experience in determination of criminal trial. So my question, sir, is that, okay, while we say that it is the court and it is the court and it's the court, I've seen situations where you get to court, the lawyers are not there. Just like Mr. Olumide has said, you go to court and you rightly said also that the prosecutors are not they are not always ready or prepared for their cases. But I just want to I want you to clarify that for these prosecutors, for some of them are police, that is at the magistrate court level, and at the high court level they are civil servants at the Ministry of Justice. I mean, what do you think? Do you think that their lack of preparedness is as a result of not well remunerated, or what do you think is responsible for this not diligence in their work?
Well, like I rightly said, you will discover that there are some times that this system works.
Yes.
Now, I found myself asking the point that why does it work in the United States? Why does it work in the UK and it's difficult working here? You will discover that and now that will answer your question first. Number one, you will see that the prosecutors and those from the Ministry of Justice, training is, most times they just dump cases on them without even checking. You see that for a private law firm, I'm sure that due point, Mr. Olumide's firm would have departments. Those who are good for litigation, those who are doing trademark, then you don't find that at the Ministry of MOJ. You just don't. Which case? Then keep person down. They just don't rape. So there is no. You just is one prosecutor that is handling everything, not checking their their competence. That's the first thing that must be done. People who are passionate about it, you see that if somebody is passionate about a rape matter, they don't even need to be paid before going to court, because they ensure that justice must be done. But these people just come to court and they don't even mind. Now picking, oh, I don't know, say, at times you just see them and they are so angry. Why is this person taking this matter like that? Number two is that the Ministry of Justice must train more people and employ more lawyers. Yes, to act with maybe argue their matter. The number of cases per person should be pegged. Because there is no way you would give an IPO that is still thinking of going to the road to collect 20 naira or 15 apologies to them and expect him to do. Of course, I know Mr. Lundala's effort. I know the number of candles we burn overnight before we go to court the next day. Whereas the IPO is at the police station drinking Ogogoro. So how do you expect that kind of person to compete effectively with somebody that has burnt 9 candles? So most times the number of cases with them should be reduced. A maximum of 10. you see that by the time they deal with it adequately, they will be coming back for more. So the MOJ and the police must ensure that the number of cases they give to these people must be reduced. Number 3, which is very important, is because you will discover that when you work in an organization that recognizes hard work and rewards it, you will see that in the United States, once you are employed as a prosecutor, as a district attorney, you rise. Yes. The number of high-profile cases you can solve ensures that you can get to the end of to the top of your department. But in this case, the IPO knows that if he solves 100 cases, he's still the same thing. But if the IPO knows that, oh, once you are able to resolve certain number of issues in a month, in 6 months, you'll be appraised and your pay will be increased. Trust me, you will see that these people will get to court on time, and so they will even write letters to the defense. Please don't use your attack point, because they know that if they know at times it's so sad that these prosecutors would even give the defense counsel that don't worry, I don't go. They already know, because they know that they have nothing to lose. Some of them would do a shoddy job to verify bail applications, but if it's your case and you know that at the end of 6 months, there are chances that you will be promoted, your pay will increase, you will get a brand new car with high condition. But trust me, you will see that things will improve. So I think that we should look at it from that perspective.
Okay. So I want us to address the issue of prosecutors at the magistrate court level, because the truth of the matter is criminal matters most of the time start from the magistrate court. And as much as you see the magistrate as being low level court, I've heard lawyers say I don't do magistrate court cases, stuff like that. So criminal matters start from these places, and policemen are the ones prosecuting. And do you think that it is still ideal in 2020 for a sergeant who had no legal background to still be prosecuting matters? Don't you think that this is not safe for society, and that it can lead for a lot of criminals getting off the hook?
Yes, I agree with you on that. That's why I said this. You see that the way they handle the matters is, you see the defense counsel is always prepared. They come with, because it's an easy ride. Most times you just see the prosecutors mumbling rubbish. You just wonder that, is this the law? At times opposing bail applications that ordinarily should not be the case. Yeah. So I think that, funny enough, you will discover that, because I remember when I was in school, a lot of policemen came back to study law. And most of them, I see some of them in Banti and some other police jurisdictions where they practice. So why don't you make it, why lawyers in the employ of the Nigerian police or the MOJ will not go to the magistrate college? Because they feel probably it's below their pay grade, it's beyond their, but in as much as they look that it's beyond their pay grade or it's beyond their level of competence, but lives are being damaged at that as well. So like Mr. Olawide also mentioned that there are provisions in the law permits the policemen to prosecute cases even up to the higher level. So what should be done is, well, 1, the law could be amended. 2, the officers who are assigned cases should have a law background. Not just anybody just sent. Of course, they don't handle intelligence matters like that. They don't. When it comes to kidnapping, there are special units for that. So I believe that such units should be trained over and over. Training is important, because every law firm sends their lawyers for training over time. They just some people sitting down, nothing. And this is sad. I think that the policemen should be upgraded, should be trained, and if it's found out that out of 10 cases or the percentage of cases given to you, you have lost out due to some ineptitude or whatever, you should be laid off or degraded. I think that when such sanctions are applied, we will see an improvement. The laws are there, it's just the spirit, it's just the political correctness to enforce them and see that justice is done.
Yeah, thank you very much. Can you also kindly properly enlighten us on the court? Because in 2020, I keep saying 2020 because I feel that at this age we should have gotten some things right? So we go to court, and as counsel, the court is not going to sit. For instance, we heard cases of court going on training vacation or something like that, and You know, you as a lawyer, you are prepared, I'm going to smash that case today like that, and you are going to court, you get to court and the court is not sitting. Do you think that is too much for the court system to be able to send, I mean, when lawyers file cases, we have our details of your law firm, phone number, email addresses on the bottom of the processes. I feel that we should be able to get 4 Naira text messages informing us that don't bother coming to court. This matter has been adjourned to so date, you know, something like that. But why is it that difficult to achieve those things in our own jurisdiction over here?
Yes, well, I agree with you. And I'm sure that every lawyer would understand what you have mentioned is a pain. I remember there was I was supposed to be before 2 courts, one in Magistrate Court in Oba and the Federal High Court in Ikoyi. And I assigned somebody to go for the one in Ikoyi. And he sent me a message that I couldn't go. You know, that night, I think I called you. I had a headache, I couldn't sleep. How would I manage? I said, okay, I'll take the 2 files, my wig and guy in the car and all that. Would you believe that after the one at the Magistrate Court in Ogudu did not sit, despite that I got there at 7 a.m., they didn't tell us anything until like 10 a.m. I had to dash to Ikoyi, and the court said, well, fortunately, I met the court sitting. My matter was number 15 or thereabout. When the judge got to number 12, he said he was tired. All of us should come back. You can just imagine. So that means that the night that I didn't sleep, the tension I had was in vain. And like you said, send it, and it's mandatory. What this is mandatory for you to put your phone number, your address, your other details. What is the point? Is it to fill up the paper? Is it not for contact? Well, I must commend the NIC, that's the National Industrial Court. You will see that they, at least compared to other courts, they send messages at times, they send you text messages, they send you mails at times to say, oh, your matter is coming up and all that. But you will see that now that the courts have been on leave as a result of the COVID-19, not one of them will send you a message that we are back in business until you go back and beg them. At times, when you even call, it's like you are stressing them. Then what is their job? So I think that the courts too should step up their game. The personnel is there, the resources is there. So it just has to do with administration.
Do you think the resources is there?
Yes, we pay filing fees.
Okay.
We pay filing fees.
Yeah.
And I'm sure that as a lawyer, even at the point of filing, if they ask me to pay SMS for SMS while the matter is on, I would gladly do it than spending 3,000 or 5,000 on foil. From the stress. If they tell you, oh, at the point of, like the banks do, they charge us for SMS. I wouldn't mind if the court would charge us and say, throughout the time that your brief will be before us, we'll always send you text messages, we'll even send you emails of the proceedings without you asking. Yeah. Pay X amount. I'm sure that 75% of lawyers will gladly do that. So I think it's an issue of administration. People need to do their jobs. They really need to do their jobs.
Wow. It's been a time well spent. I've learned, I've unlearned, and I'm still relearning. Thank you so much, gentlemen, for coming on this show. I'm very glad and I'm so happy that we were able to call you on short notice that you made it down. Thank you so very much. I will hope the next time when we call, you always grant our invitation. All right, in conclusion, all stakeholders, the courts, the lawyers, the accused persons, the prosecutors, the judiciary as a whole, we are all stakeholders in administration of justice system. We have, the gentlemen have revealed to us that we all have a role to play in ensuring that there is no delay in determination of criminal trial. I now use this opportunity and this medium to call on all stakeholders that let us all sit down on the round table, let us discuss, put heads together and see how this issue can be put behind us. It is very essential that justice is gotten in time. Like they say, justice delayed is justice denied. Thank you so very much. And again, this show is put together by Hereford Foundation, an NGO based in Lagos and focusing on decongestion of Nigerian prison. I use this opportunity to call for justice for Tina and justice for Uwa. Thank you once again for joining us in this show. My name is Oluyemi Orija. Have a beautiful day.